Hey, good morning, everyone. We're ready to begin with our next witnesses. We've got date certain, so I think Mr. Holman, you're up, or Mr. Cleveland.
Mr. Chairman, Southern Alliance for Clean Energy and Coastal Conservation League would call Ron Benz. My colleague Liz Jones will be doing the direct.
Would you please state your full name and your business address for the record?
My name is Ronald Binz, B-I-N-Z. My business address is 333 Eudora, E-U-D-O-R-A Street, Denver, Colorado, 80220.
And whom are you employed and in what capacity?
I'm self-employed as a consultant in public utility regulation and energy policy.
Would you please briefly describe your... Excuse me, sorry. Go ahead, Mr. Benz.
I have a DBA, which I call public policy consulting.
Thank you. And would you please briefly describe your background and qualifications?
I've been working in energy and telecommunications regulation since 1979. Over that time, I've been in and out of government for 12 years in the 1980s and 90s. I was the state consumer counsel, the same job that Mr. Commissioner Elam held here in South Carolina. I was out of that job for 5 years, when the governor appointed me to chair the Public Utilities Commission of Colorado. I did that for 4 years from 2007 to 2011. I went back to my consulting practice for the time since then.
Did you cause to be pre-filed 29 pages of direct testimony in these dockets?
I did.
Did you also cause to be pre-filed 11 pages of surrebuttal testimony in these dockets?
Yes, I did.
Do you have any changes or corrections to either your direct or your surrebuttal testimony?
I do not.
If the questions put to you in your testimony were asked at the hearing today, would your answers be the same?
They would be.
Mr. Binz, did you prepare or cause to be prepared 6 exhibits that were attached to your direct testimony?
Yes.
And they were identified as RB1 through RB6?
That's correct.
Did you cause a revised version of one of those exhibits, RB4, to be filed?
A correction to that, yes.
Thank you. Aside from that correction already made to RB4, are there any corrections or changes to be made to those exhibits?
No.
Were those exhibits either prepared by you or typical of documents relied upon by an expert in your field informing his or her opinion?
Yes, that's correct.
Mr. Chairman, I would move to have the pre-filed direct and surrebuttal testimony of Mr. Ron Binz entered into the record as if given orally from the stand.
Mr. Benz, pre-filed direct and pre-filed surrebuttal testimony will be entered into the record as if given orally from the stand.
Mr. Chairman, I would also move to have the 6 exhibits that were attached to the direct testimony of Mr. Binz entered into the record as the next hearing exhibit.
Okay, Mr. Benz, 6 exhibits, RB1 through 6, will be entered as exhibit number 93.
Thank you. Mr. Binz, did you prepare a summary of your direct and surrebuttal testimony?
Yes, I did.
Would you please deliver your summary to the commission.
Thank you. Good morning, Commissioners. It's a privilege to be testifying before you today. I see some old friends, and I do mean old. The purpose of my direct testimony is to offer recommendations that may assist the Commission and the parties to successfully resolve the difficult issues in these three interlocking cases. As a former Public Utilities Commissioner, I appreciate the complexity of the issues surrounding the proposed change of control of SCENG and the disposition of the stranded costs created by the abandonment of the VC Summer nuclear units. In my opinion, as a former regulator, the Commission should have two main guiding principles in deciding these cases. First, how does the treatment of stranded costs in this decision on the merger affect consumer interests? And two, does our decision on the treatment of stranded costs in the proposed merger advance the public interest? As President and General Dwight D. Eisenhower once said, "When you can't solve a problem, enlarge it." This advice applies to the challenge facing the Commission now. As I discussed in my testimony, the merger/stranded cost challenge might be solved in a way that is fair to both SCENG and its ratepayers by introducing two additional issues. First, securitization of the stranded assets, and two, SCENG's procurement of energy resources. Adding those two issues to the analysis will give the Commission and the parties more options for the Commission's decision or the parties' settlement discussions in these cases. Securitization, essentially refinancing the VC Summer debt at a lower interest rate, can significantly reduce the cost of the abandoned plant that ratepayers will have to bear. And adopting a competitive framework for resource acquisition provides SCENG with a path forward toward greater investment in South Carolina. That will move the state past this failed nuclear plant and toward a clean energy future. I offer four main recommendations for the Commission's consideration. First, in deciding the questions of stranded cost recovery and whether to approve the proposed merger, the Commission should keep in mind both consumer interests and the public interest, including whether its decisions advance state energy policy. It is not the duty of regulators to ensure the bond rating of a utility, or even that the utility remains solvent, except as those outcomes affect the service customers receive and the justness and reasonableness of the rates customers pay. Second, as proposed, the merger does not adequately address state energy policy goals. Possibly the clearest statement of public interest goals in the energy realm in South Carolina is found in the State Energy Plan, which repeatedly commits to more diverse energy resources, more energy efficiency, and more renewable energy and greater energy efficiency. Renewable energy and energy efficiency are low-cost, low-risk resources that can help customers save money on their bills. To ensure that the merger is in the public interest, the Commission should place conditions on the merger that will move the state forward towards achievement of the state policy goals, encouraging the use of clean energy resources. Third, as a condition of any approval of the merger, the Commission should require the merger parties to use securitization for the recovery of any approved stranded costs of the abandoned VC Summer units, contingent upon legislative action. In the utility context, securitization means financing a portion of a utility's assets with low-cost bonds that are repaid by a dedicated revenue stream resulting from a monthly fee on customers' bills. In this case, the asset is a regulatory asset. the utility's right to recover some amount of the stranded costs of the VC Summer plant, as approved by the Commission. Under securitization, the Commission-approved regulatory asset is sold, in quotes, to investors, that is, bondholders, removing it from the utility's books. Customers stop paying a return to the asset to the utility and begin paying the bondholders at a much lower carrying charge. In South Carolina, we might expect the carrying cost to be around 3.2%, much lower than SC E&G's weighted average cost of capital of 8.17%. This works to the customer's benefit because the utility's base rates go down more than bond payments go up. Over the period of repayment, securitization can save customers a very large amount of money. Approximately 21 states and the District of Columbia have enacted legislation that enables the use of securitization and provides a commitment that the state will not interfere with the repayment of those bonds. Exhibit RB4 to my direct testimony contains a list of 65 instances in which securitization was used by U.S. utilities. The example covers securitization transactions in 17 states from 1997 to 2018. A recent example that is directly relevant to the VC Summer situation comes from Florida, where Duke Energy Florida abandoned the Crystal River Nuclear Unit 3 following a botched attempt to repair cracks detected in the containment vessel. The Florida PSC approved the plan in October 2015 that used securitization to finance $1.3 billion in stranded costs over 20 years. The bond carried an interest rate of 2.72%. Much lower than Duke's weighted average cost of capital. Duke Energy estimated that on a net present value basis, securitization saved customers between $600 and $700 million. Finally, my fourth point is that as a condition of any approval of the merger, the Commission should require SCE&G to conduct an open, transparent, competitive solicitation for any new energy resources that may be needed to meet the company's energy and capacity needs. Rigorous competition among suppliers will ensure that the Commission can obtain the lowest cost consistent with the needs of the utility and the state. When securitization occurs, the utility's rate base will shrink as some amount of stranded costs is moved off its books. This will reduce earnings while simultaneously making a large amount of cash available to the utility. CCL and SACE see this as a unique opportunity to shape the future of energy in South Carolina. SCE&G can recycle the capital formerly invested in the VC Summer units into clean energy investment, moving South Carolina away from fossil fuels and replacing some of the earnings lost in the sale of the regulatory asset. I have direct experience with establishing a new process for competitive procurement of energy resources. As chairman of the Colorado Public Utilities Commission, I led the development in 2008 of a new rule guiding competitive acquisitions of energy resources by Colorado's utilities. The Colorado rule carefully specified the details of the solicitation and required that the process be overseen by an independent evaluator to ensure the fairness of the process of evaluating the offers submitted in response to the RFP. The resource expansion that followed adoption of the Colorado competitive bidding rule was widely seen as very effective. The purpose of my rebuttal testimony is to respond to portions of the rebuttal testimony filed by the applicants, including the testimony of witnesses Ellen Lapson, John Raftery, and Robert Blue. SCE&G witness Lapson cites a number of reasons why securitization of the stranded VC summer costs is not a viable option to lower costs for ratepayers. Ms. Lapson is correct that certain conditions must be met before securitization can be used. Most importantly, enabling legislation will be necessary. However, the Commission could make its ruling on the merger transaction contingent upon the use of securitization for certain stranded costs when and if securitization becomes available in the future. Legislatures in many states have passed such formulaic laws authorizing securitization so that there's no longer any doubt about the ingredients necessary to satisfy Wall Street and achieve a AAA rating for the securitization bonds. Ms. Lapson also states that securitization is, quote, inconsistent with the conditions of a merger, close quote. But the Commission is not bound by the terms of the merger agreement. It is well understood that the Commission may apply preconditions to its merger approval to ensure that the merger is in the public interest. Ms. Lapson then lays out a litany of other factors, each of which has been addressed by other commissions, legislatures, and utilities to make securitization work. In other words, none of these conditions or steps is a barrier. 17 states have successfully used this financing mechanism, some of them multiple times. Here's my response to each of her 4 points. 1, it would be prudent to undertake a legal analysis, as Ms. Lapson recommends, but South Carolina law appears not to provide for voter initiatives that could theoretically threaten the bond repayment. Second, detailed model legislation exists and has been developed to implement the strict requirements that will secure Wall Street's support for the bonds. Third, as Moody's points out, there should be no concern about state legislatures reneging on a state pledge to repay these bonds. Such an attempt would be answered with a takings legal claim and likely the claim of impermissible retroactive legislation. The actions required of the Commission in overseeing the repayment of these bonds are familiar to regulators. These are the exact actions that regulators undertake today with cost tracking mechanisms. SCE&G witness John Raftery testifies at length to the Commission's practices with regard to renewable energy and the process for procurement of distributed energy resources. But those existing practices and processes do not preclude the Commission from adopting my recommendation that the company initiate a competitive bidding process for resource procurement. Dominion witness Robert Blue claims that the matters of energy efficiency and renewable energy are beyond the scope of this proceeding. Witness Raftery points to the state energy plan and the ongoing stakeholder process to implement that plan, then states that it is not appropriate, quote, to short circuit, unquote, that process in this proceeding. As I explained in my direct testimony, this merger provides the Commission with an opportunity to impose conditions on the merging parties that will ensure that the merger is in the public interest. Such public interest considerations are clearly not beyond the scope of this proceeding. On the contrary, they are core to the Commission's responsibility in a merger review. This concludes my testimony.
Witness is available for cross-examination.
Thank you. Mr. Gile?
Thank you, Mr. Chairman. Bob Gile for Friends of the Earth and Sierra Club. Thank you for your testimony, Mr. Benz. I have no question.
Other parties? ORS?
Good morning, Mr. Chairman. Good morning, Mr. Benz. My name is Andrew Bateman on behalf of the Office of Regulatory Staff. I have just one brief question, potentially brief. Mr. Benz, in other states, when securitization was enacted, were the utilities harmed?
No. As a general matter, utilities come out of securitization in pretty good shape. Securitization was used primarily, the first round was used in the United States when restructuring took place in the northeastern states, in which a competitive market was established, devaluing the assets that were going to be bid into that. Essentially, the plants were too costly to compete in a competitive market, so their value came down. And the utilities recouped that loss in value by securitized assets.
That's it. Thank you so much, Mr. Benz.
Other parties, Cross. Company?
No questions from SCNG.
Commissioners? Whoop, hang on.
No
Sorry.
questions from Dominion either.
Sorry about that. I got ahead of myself. Got excited. Now, commissioners.
Mr. Chairman.
Commissioner Whitfield.
Thank you, Mr. Chairman. Good morning, Commissioner Benz. Good to have you with us.
Thank you very much. It's like one of those letters where you write the name Mr. Benz, you cross it out, and you put Ron in, right?
That's right. Yes, sir. Good to see you again. Good to have you with us today. Got a couple of questions for you. On page 15 of your direct testimony, of course, you discuss what the securitization issue that you summarize so succinctly. Under current economic conditions, would the company be able to securitize the assets in the magnitudes discussed in this case?
I think that will require further analysis. Several times in my testimony, I took pains to say that portion of the permitted costs. There is, of course, ultimately a limit to how much could be securitized. I don't know what that number is. It certainly has been in the billions and multi-billions across the country and other cases. Again, if it's $1.5 billion, probably $2.5 billion, I think that would be possible to securitize that much. It depends on a lot of things. Dr. Varadarajan will also be able to address that very issue.
You talked about no harm to the utility. You just then said, I think, to Mr. Bateman, you talked about the benefits again of the securitization and not harming the utility. But what about risk to ratepayers in securitizing the assets?
Well, it's the same risk that ratepayers face when you impose any sort of rider on their bills, whether it's to recover the cost of other pensions and benefits, or whether it's in fact to recover costs of fuel. If there's a risk to ratepayers, it is that charge is going to follow them for 20 years. And by the way, we assume that the recovery of the asset would also follow them for 20 years. So in that sense, there's equilibration between the two courses. Customers who leave the system but who are dependent upon transmission and distribution would continue to pay that fee. Otherwise, Wall Street's not much interested if everybody can bail out of paying it. But if some do, if some industrial customers, for example, are able to get out of paying it, and I'm not sure how they would do that, but if they did, the amount paid by all customers is ratcheted up slightly to pick up that difference. So in that sense, there could be you might call it a concern for ratepayers that a true-up or a make whole would be part of the deal so that bondholders are willing to accept the AAA valuation that the bond has been given.
I want to talk just a minute, a little more specifically to South Carolina, and I'm not sure if you remember from your NARUC days or maybe in preparation for this case the exact lay of the land here, but you know that, of course, Santee Cooper was 45% owner and state-owned, not under any jurisdiction of us, of the commission.
Yes.
So my question is, And you also know that SC&G has sought huge federal tax credits in pursuing the abandonment as well. So if the companies pursue securitization, and if title is transferred of these assets to the special purpose entity or special purpose vehicle, whatever term you want to use, would it be possible, number one, for the company to reacquire the abandoned assets, in your opinion, in the future? Or would it be possible, who would, in your mind, who would own the assets? Would it be possible for the company to reacquire the abandoned assets, or would Santee Cooper have title? What would be your opinion on that?
I'm not the lawyer in the room here, but I'll give you my understanding. The special purpose entity and the bondholders to which it reports are the owners of the asset. And by the way, remember the asset here is a regulatory asset on the books. It makes no difference whether the site is bulldozed or not. This commission, under law, has the requirement of allowing a utility to recoup prudently made investments. And to the extent you find some portion of this plant to be prudently incurred, the utility has the right to receive that. That right is transferred to the special purpose entity, which could be part of the holding company. There's no requirement that it not. The main requirement on the special purpose entity is it be what's called bankruptcy remote. If the utility goes bankrupt, this entity survives and has the right to that revenue stream. So, could that right be reacquired? The answer is yes. The provisions of law, which I'm familiar with, in every instance with which I am familiar, provide for the refinancing or sale of the asset which the bondholders have acquired. There's no requirement, as far as I know, on who can acquire that, because the law follows the successor to that original contract. So I don't know what the circumstances would be under which they would want to do that, but as far as I'm concerned, the provisions of the law we're assuming is passed, the provisions of that would apply to any bondholder going forward, whether it's the original set of bondholders or someone who steps in their place.
And Commissioner Benz, part of your answer leads me to my next question. Other witnesses have said that this process, the asset, would still be on the books. I think I'm referring to Ms. Lapson probably. And your testimony is that it would be removed from the books. So
the laws in several states state that the commission shall not consider that an asset of the utility and shall not consider the revenues and payment of that to be revenues of the utility.
So the legislation in these other states you're referring to, the way the legislation is written, all the ones you're familiar with, it is removed from the books.
Yes, it is.
So it's the way the legislation's written, and all the ones that you know of, you don't know of any that have it where it's still on the books.
No. Now, a caveat I want to add, some of the rating agencies, they actually waffle a little bit on the question, but some of the rating agencies say that they take that debt into consideration in forming their overall opinion. Others do not. So, as you can imagine, when you're at a Moody's or a Fitch or an S&P, exactly what you look at and exactly what weight you give it is to some extent an art. I mean, that's why they get paid the big bucks. And some of them say, I think the Moody's piece that I included in my as an exhibit says that it may consider those assets in formulating the overall rating for the company. But in terms of the regulators, when you're setting rates, those costs are gone as far as you're concerned. It's no longer rate base. It's no longer income.
Well, that said, Commissioner Benz, and without having this legislation in place in South Carolina, in your opinion, as a former regulator, could the commission order the company to securitize these NND assets without the legislation already being, I think you come close to suggesting that in your testimony that you could put that as a condition, but in your opinion, we could put that in the order without the legislation already being
Yes,
here.
I see no barrier to that. Again, not a practicing attorney. I'm not stating a legal opinion, but this commission can condition a merger on any legal requirement, and I can't see why that one would not be a legal requirement. The legislature may fail to act, so you're doing this on a contingency basis, and if the legislature never did act, the merger would go forward on terms that did not include securitization. Now, if you wanted to make the whole merger contingent upon the legislature acting, that would probably queer the deal. The companies are not going to be interested in waiting around to see if the legislature passes that. But I think if you identify securitization and the hundreds of millions of dollars that will be saved that way as a condition of the merger, and instruct the parties that they shall securitize when and if there is authority to do so in South Carolina, I see no impediment as a regulator familiar with these kinds of matters.
Well, thank you for that answer, because that's a fine line here. We're certainly not lawmakers, and we've been told we're not policymakers too. So certainly appreciate your.
I'd push back on that a little bit.
Well, not in that position, sir. I'm not in that position, sir. Commissioner Ben's not. Lastly, you probably looked at this in preparation for this. Your suggestions about procurement of energy resources as a former regulator. Again, in South Carolina, I don't know if you're familiar, but our commission doesn't quite have the same IRP, Integrated Resource Plan laws, that your state has or that other NARUC states has, and that makes it a little difficult too. We receive IRPs, but we don't really have the teeth, the ability to do the things that other states can do. And just maybe if you could touch on that.
Sure. And I wrote my testimony with full knowledge that you're one of the states, and there are a lot of them actually, who do what is called receive an IRP. You don't approve an IRP.
Correct.
They basically check the box by filing something with you. You might have a hearing to understand it,
correct,
explore it, but you're not approving it. In states where it's approved, like Colorado, what the utility gets out of that, just as an aside, is they get a rebuttable presumption of prudence. That if something is in the IRP, which is approved by the commission, then they get, when cost recovery comes up, there is the presumption that that investment was prudent. Just to set it up. Now, in your case, you don't have anything resembling pre-approval. So a utility is fully at its risk for building something. I'm leaving out the Baseload Review Act, but a utility is not presumed to be prudent simply because it was included in their IRP. That's how I understand the situation here. That said, I don't know, and so armed with that knowledge, I carefully steered around any requirements that I think would be IRP-like. What I'm suggesting is that you specify the manner in which they acquire additional resources, not which ones they acquire. In this day and age, solar and wind are being bought by utilities not because of some requirement in their law for renewables, but because they're low cost. I mentioned in my testimony that, and I'm using Colorado repeatedly, but I could put other states in the same position. Colorado builds gas capacity for capacity and buys wind and solar for energy. And that ends up being lower cost than just the gas capacity alone. So you're going to face the question someday, did the company make the right decision? Because you will not have approved that in advance. So eventually they come to you for approval and rates. But my suggestion is that you will get better results. The utility will probably learn things it doesn't know by asking the market, okay, here's what we need, who can supply it at what cost. I don't know if I put this in my testimony or not, but in Colorado and other states, the utility often gets 10 to 15 times the amount of capacity bid that they're requiring. If they want 300 megawatts, they may get 4 gigawatts bid. That gives you a lot of flexibility when you're then acquiring that. So an open solicitation, we call them all source. I don't see why this commission, even with the limitations on IRP, I don't see why you couldn't specify the manner in which the utility acquires new capacity.
Well, thank you, Commissioner Benz. It's good to have you with us and good to see you again, and certainly appreciate your testimony, and thank you for being here. That's all I have, Mr. Chairman.
Thank you, Commissioner.
Thank you. Commissioner Irvin.
Thank you, Mr. Chairman. Mr. Benz, good to have you with us this morning. What's the difference between a company-established special purpose entity and an independent special purpose entity?
The answer is I don't know. It seems to me that special purpose entity says it all. I mean, it's a term that's familiar to people with all sorts of financing arrangements, typically in the real estate business, in the energy production business. SPEs are set up probably for every wind farm that's set up in this country. And the reason that's used is to separate that out from the neighboring assets, whatever they are, to the benefit of both. So I think the term SPE probably includes the concept of independent. Now, if one wants to use this, I can imagine ownership of the SPE or housing of the SPE in the utility versus outside the utility. That may be the distinction somebody is making with that addition of the word independent. But I don't know. I don't know of any. Not that I'm a lawyer, but I don't know of any legal difference in those terms.
To follow up on your earlier suggestion that you make the merger contingent upon securitization, if the Commission chose to go that route and then the General Assembly failed to act, what would be the next step in the process?
I don't anticipate there would be any next steps. You will have approved the merger, if you will, on the hopes that the legislature passes that. If they don't, that's on them and not on you. By the way, I should also say, and this is relevant to my answer to you, securitization can be done at any point. It doesn't have to happen simultaneously with the merger or with the disposition of all those assets. I've been working with the Colorado legislature on legislation in Colorado. It does not now exist. But one of the things that the members of the General Assembly I've been working with, one of the things they have their eyes on is a pot of money sitting on the books of Xcel Energy. I think it's about $430 million left over from stuff back when, and that will be rolled into the securitization. I should say the utilities aren't typically crazy about securitization. They would rather have that asset on their books generating cash going forward. That's their first choice. But if they're in danger of losing that asset entirely through a disallowance, then securitization starts to look good. And I believe that's what happened in Florida with Duke on that Crystal River plant. They might have lost the whole thing, and they agreed to securitization, and the story goes from there. So back to your question, I think that you're signing off on a merger with conditions, and the conditions are not a requirement of merger. Well, the imposition of the option is part of a merger approval, but the failure of the legislature to act would not invalidate the merger or the decision. That's
So
again,
in legal,
how I would do that. Yes,
in legal terms, it's not a condition precedent to merger.
good word.
It's really more of a suggestion to the
Well,
legislature.
I think your order would say if securitization is available, you shall use it.
Okay.
I don't think it says either make it happen or lose the merger. You're not saying that.
So it's not a condition precedent.
That's right. That's right.
The merger could go forward, and then if the legislature acts, then the utility
Shall.
shall securitize the debt.
That's how I would.
Basically, a refinancing of the debt that's in the benefit of the ratepayers.
Yes, exactly right. And again, you can explicitly say we are approving whatever pass-through of assets you are approving explicitly on this being used when and if it's available. I don't know what the temperature of the legislature is on this. I don't know if you do, but it'll be their decision. And there could be several $100 million. There will be several $100 million on the line.
And based on your example, the rate cut, so to speak, that would come from securitization, can you approximate in any closer terms how much of a savings it would be to ratepayers?
It depends, but I can give you some ballpark numbers. And I think I learned how to say his name today, Vardarjan. I think he'll be able to shed some more light on that. But we looked at a lot of states and the securitization numbers. It depends, of course, on the bond issuance percentage, and the bogey is the rate of return of the utility. We know the rate of return of the utility, at least in 2018, will be 8.17%. We're estimating that the bond would, I said 3.2% in my testimony. That's probably edged up a little bit because AAA long government securities have edged up a little bit. However, if you're talking anywhere near a 5% spread, 4.5% to 5%, we've run the numbers in a number of jurisdictions, and the savings turns out to be 40 to 50% of the nominal value that you're financing. So on $1 billion, you might expect 400 to 500 million. It's over 20 years, but that's also a net present value. So it's not the nominal savings for 20 years. It's that stream discounted back to net present value. So it's comparable to the billion. That's what was the case in Florida, and that number is attested to by Duke. This is not somebody's imagination. And there are firms in this country who are very active in the area of securitization. I mean, frankly, it's a place where bond houses can make some money, so they're happy to see it happen. And you will find on their websites these sorts of estimates. So I would say conservatively 400 million per billion. It might be higher than that.
You mentioned that you have some type of model legislation. Is that available? Is it readily available if someone wanted to find it?
Yes.
Where?
Well, it's on my website right now.
Okay.
So, but if the commission is requesting what I might call model or prototypical legislation, I can provide that.
Is that what was used in Colorado?
Yes. Again, the bill didn't pass first time through. It's going to be reintroduced this year, and the expectation is it will. Depends on how the utility feels about it. They will influence it, but we think it will pass this year.
Thanks,
and it's modeled after numerous other states. I mean, I did a lot of the work on it, and we took Florida as an example, but we also took a number of other states, and the commonalities are very obvious. Wall Street just basically wants the state to say, we're not going to change it in law. Now, they could, but they won't. and our commission says we're not going to change this. And that's good enough for Wall Street.
Thank you, sir.
Ms. Jones?
I would just add that if the commission would like, we could provide that model legislation as a late filed exhibit.
Yes, let's do, and let's have that as exhibit number 94. Commissioners, other questions? Commissioner Hamilton?
Thank you, Mr. Chairman. Good to see you, Mr. Bentz.
Same here.
Been a while.
I'll call you O'Neill. You call me Ron. That'd be okay.
That'll be a wonderful thing. Good to have you with us today. Let me kind of recap. I think Commissioner Whitfield and Commissioner Irvin pretty well plowed the ground of securitization. And I assume from what we've heard today that this should be a part of our order, merger or no merger, that the two should be used subject to the legislature action.
Yes, and the amount that can be securitized with minimal impact on the utilities ratings may be changed by merger versus no merger. So, excuse me, the answer to your question from my perspective is yes, but it might be different amounts depending upon whether the merger is consummated or not.
In your view, how would Wall Street view this?
Well, I provided you with 3-month-old discussion from Moody's, and they the magic words, of course, with a fixed income analyst is credit positive. They viewed securitization as credit positive. There were a couple caveats to that. You can read it. It's an exhibit to my testimony. There were a couple caveats to that, but essentially they said in most cases it's credit positive. If there's too much of it relative to the size of utility, that can be negative. And if the utility cannot respond to the future loss of revenues with reinvestment of the dollars, remember, they get a check up front for the full amount that they're financing. They sold that asset. The utility is going to get whatever amount of money in cash that was securitized. And they need to reinvest that in ways that restores the income that they've lost when that regulatory asset was sold. So it depends upon the essentially the health of the utility and the size of the utility. That's why I say it may depend upon the merger.
Did you do any review as to the point of where the SC&G could survive and be a healthy, reliable energy producer for our ratepayers if they stood alone, other than merger?
That's a question that you are leading Dr. Vardarjan for. He did that very analysis.
You agree with him?
Yes. I've worked with Uday in other matters. I know his work, and although I cannot vouch for the numbers per se, I trust the work he does on this.
We've had witnesses that told us that the regulator stability had dropped to the bottom third from where we at one time were in the middle half of it. Do you think the securitization would improve the view of regulator stability?
Well, I think it would show several things. I think it would show that this commission is flexible and creative in the sense that you're using a tool which is only sporadically used in the current day. Remember, there's 67 examples of this going back over 20 years, so it was very popular. And in recent years, it's starting to show up because of the abandonment of coal plants and the abandonment of nuclear plants. That's what's driving its rediscovery. Again, I valued my commission's reputation on Wall Street as being predictable, no surprises, that sort of thing. But that doesn't mean we weren't creative. That doesn't mean we didn't do things which others didn't. It meant we did some things which were, if not first, then early. So I can't imagine that. Again, everybody understands what you're faced with. You're faced with a $4.5 billion hole in the ground. I mean, that's the problem. And I think any way that this commission can act to solve that problem in the sort of least painful way across everybody, I think would be valued.
Ron, I appreciate this very much.
Sure.
It's good to see you full speed ahead again.
Thank you very much. Are you still chair of the gas committee?
Yes. No,
No.
we turn that over to some younger folks. Thank you.
Thank you.
Commissioner Elam.
Good morning, Mr. Benz.
Good morning, Mr. Elam.
It's been a long time since I was a peon on the Nasuka Telco Committee, and you were the chairman, I believe.
You can just call me Mr. Chairman if you'd like.
That'll work. The thought had occurred when he was. Of course, it would just confuse somebody. I'm looking at.
Remember, I always have the mic last.
And even if you didn't, I'd lose. On page 9 of your pre-file direct, you talk about the Colorado Ute Electric Association case. And as I take it, you say there were distribution cooperatives, and this was just the transmission generation part of it.
That's right.
Do you have another example of just, in essence, a vertically integrated utility like SCE&G?
Nothing that occurs to me. I would be happy to respond in writing if I come up with something. I don't. There haven't been that many utility bankruptcies, large utilities.
In the Colorado case, did the retail rates for the distribution cooperatives go up?
Not because of the bankruptcy. They went up just prior to the bankruptcy because the G&T was seeking higher wholesale rates and got them twice. And then the third time, the commission said, that's enough. We're not going to raise your rates anymore.
Okay.
As far as I know, and there might have been, there certainly was no large, I mean, the answer, I believe, is no, because the generation and transmission assets were acquired by two other companies, one IOU and one G&T, another cooperative G&T. And they accepted the tariffs on file as far as I know. So I don't recall any increase at that time.
Mr. Elam, make sure you get in front of your mic. Somebody out there might want to hear you.
I'm digging a hole faster than I can fill it back in. One of your colleagues, I believe, testifies about the application of securitization to Santee Cooper as well. Did you look at that issue?
I did not.
Okay. And Santee Cooper generally doesn't really have equity financing, so
That's right.
maybe the gap between a securitized number and what they pay for capital might be a little narrower.
Yeah, I don't know what their what interest rates they face in borrowing, but it won't be lower than what the securitization would yield.
And lastly, the last part of your testimony, talking about an open process for capacity bidding. You've testified, have you testified on behalf of renewable energy suppliers?
Not
really
on that topic.
Okay.
I believe.
Are you aware of any states that have that sort of open bidding capacity where they would favor, say, solar plus storage or wind plus storage over simply solar or wind?
Yes and no. I mean, I know the general trend. I can't probably pull out states and give you the specifics of those states. My main point with respect to that is that utilities don't usually go there. They are, they know what they've been successful with in the past, and they tend to add capacity when capacity is needed, and they just move on. And the new world out there is that these renewables, as long as the federal tax incentive exists and thereafter, are going to be cheaper than fossil fuels as an energy source. You still need capacity. In order to get those kinds of proposals brought forward, you need an open call. You need an open solicitation. And then suppliers themselves, I don't know who it will be in this case. It'll probably be NextEra Energy, among others. They do those sorts of bids, but lots of other people do too. You'll probably have state entities able to supply that. And then it's up to the utility to evaluate all those. And wind plus storage or solar plus storage will have a place in the portfolio. If you got the storage with solar, that means you probably are not going to need capacity around the clock to institute the solar. If you do solar on a standalone basis, you're going to need some amount of capacity on hand to meet, well, at night for starters, but also when you have incidences of cloud cover, things like that. Again, these are the kinds of problems engineers love to solve. And what I saw in Colorado is that we allowed utility to look at bids of all sorts, and they began to put together a portfolio, which was different than what they had had before, and they're operating the system at extremely secure levels. So there's never any room for lowering reliability. That has nothing to do with that. It's just that how you change the operations of your control room. There are times in Colorado, it's usually 4 a.m, but there are times when Colorado is 60% wind. And if it's not wind, if the wind drops off, the gas plant comes in. So it's just kind of what you'd hope. But utilities didn't always do it that way, and they're not inclined to sometimes. Sorry.
Oh, no, sorry. I didn't mean to interrupt you. You made the statement that renewables are lower costs, so utilities are moving toward them. Are you talking about in a retail competition environment as opposed to vertically integrated?
Nope. Xcel Energy Colorado, I'm just very familiar with them, so I'm going to use them as an example. They just bought 250 megawatts of solar because it was cheaper. Straight out. There's nothing else to the story. They're not Xcel Energy in Colorado is running ahead of its state-mandated renewable portfolio standard. It's not binding on them right now. And so their decision to do that was not driven by the RPS.
Are they otherwise pretty set for capacity, though?
It's a growing state, so that was in the context of additional gas capacity, too. It was an IRP. I mean, that's how it came about. And the 250 megawatts of solar was added in the context of an IRP, and the addition of the solar brought the total cost down. That's kind of the important part.
Okay. Thank you.
Thank you.
Commissioner Howard.
Good morning, Mr. Benz. Welcome to, in this case, close to sea level. I've got a statement that's conflicting in my mind, and maybe you could clear it up. But there are two statements I want to discuss with you, and one of them was, I read somewhere, and don't ask me where, but the only two people, or the only two parties that really support securitization are the utilities and Wall Street. Both you state the utilities did not support securitization that much, and in this case, apparently neither does the utilities here. Where would that statement come from, and what would be the found by a statement like that?
Well, you said don't ask you where you heard it, but I'd really like to know where you heard that. Utilities, depending on the situation, if they are in danger of losing assets, they're going to favor securitization. That's an easy one, okay? You know, if their choice is to write off a chunk of plant, of investment versus recover it through securitization, lose your future earnings on that plant, but substitute that with upfront cash, they will take that. I didn't get all of the blow-by-blow in Florida, but I don't think Duke was initially supportive of it, but eventually they decided, in the case of the Crystal River plant, that that was their best out. You said Wall Street, yes, but it's not, well, Wall Street does support it. I would say customers do in many cases. We've had consumer organizations in my state backing legislation. There were some twists in our legislation, which we can get into if you want to hear about it. But I think there's, if you make the assumption that the utility is going to recover this anyway, if you're passed over that bridge, then securitization is definitely a better deal for customers. If you want to hold out the possibility of some way down the road of declaring that this was an imprudent investment and should be thrown out 5 years from now or something like that, then you might, because I've heard this done, oppose it at the front end because this is giving away to the utilities, giving the utility the recovery of this cost when they shouldn't ever have gotten it. Well, you know those kinds of arguments and who they come from, and I tend to discount them. Utilities have a constitutional right to recover prudently incurred investments. It's a federal constitutional right. So I start there. If they're going to recover it and securitization is available, we should use that, especially with respect to abandoned plant. I mean, another way of saying it, and you'll hear this a lot too, why should they get a return on a dead asset? Okay, I mean, there's no risk. It's just a number on their books. Why should they get 8.17% return for the next 20 years on that asset? A lot of people ask it that way. And so securitization is a close relative to removing the equity return on an asset. Sometimes commissioners do that. They just say, we'll pay the debt, we'll make an adjustment in your overall rate of return calculation and assign debt only to that asset so that you're not marking it up with your equity return. That's done by some commissions. Securitization is very close to that. It's saying not only we're going to use debt financing, we're going to do a special kind of debt financing where the payments are pledged, the repayment of that bond, and Wall Street says, well, this is a safe bond, we'll give it AAA, and therefore you get the 3% interest. So you can kind of get there in two different ways. But I think securitization, again, I don't know the position of the parties in this case. I don't know if the utility feels it's in danger of losing a chunk of this investment or whatever, but I do know the commission's in a position to save customers money by using securitization.
Another question. Talking about Wall Street, one of the issues or one of the complaints or disadvantages of securitization is what I've been told is read is the excessive high fee charged by Wall Street. Do you find that to be true?
I don't think it's any higher. I mean, first of all, I've looked into that, and our state statute, contemplated state statute, identifies that as an issue that the commission should oversee. We gave in our law the commission authority to approve the underwriter, to make sure that you don't get favorable sweetheart deals being done in that context. So the answer is it's possible. But as a general matter, it won't be any more than a typical bonding transaction. And there's always people who walk off a lot of money, bond attorneys and bond houses. They always take care of themselves first. But that's a small number in comparison to $1 billion or something like that.
Thank you. It's good seeing you again.
Thank you.
Thank you. Commissioners. Mr. Benz, just one quick one for me. I've heard several times about different debt that if we did securitization, different debt terms, 30 years, 50 years, that would have substantial penalties involved. How does that affect plus or minus, or positive or negatively, when you're trying to work into this whole equation?
Well, typically longer tenor bonds are going to have a higher coupon rate. So the number that I've been working with, just as a theoretic matter, is 20 years. It could be longer or shorter than that. If it's longer, you'll see a higher coupon rate, but given that the payments are stretched out, you might actually see a higher net present value of savings. I mean, if your discount rate is larger than your coupon rate, if your personal discount rate, whatever, however you want to call it, is a larger number, then stretching things out looks better. There's obviously limits to that. You're going to be making, if you do this, you're going to be making a decision on ratepayers 20 years from now or 30 years from now. And I guess the question is, what does equity command? Who should pay off this asset if you are giving recovery of it? So I think 20 years is enough. It's more or less the time frame the utility would use for plant. I mean, 30 years would be maybe at the outside. I think in Florida, the Duke recovery period is 20 years, if I remember correctly, for $1.3 billion.
But with the terms of, I think the two different terms, 30 and 50 years, is the current debt that would have to be refinanced into a securitized debt. You know, and if there were substantial penalties for redoing that.
My apology.
Yeah, no, that's okay. I learned something new anyway.
If you approve the securitization, say of $1 billion, the utility gets a check for $1 billion. Now they have options for how they dispose of that money. They might retire debt, but if there was a penalty associated with the early return of bonds, that would not be a good idea. You'd look at it probably wouldn't be a good idea. You have to roll that in, the penalty in. We are suggesting, and again, Dr. V will be the best person for this, we're suggesting that some of that money should be reinvested in capacity that's going to be needed for the hole in the resource plan that the removal of the VC summer units creates. If not this year, then in future years. They can also, it's less advantageous, but they can purchase equity, buy back shares if they want to do that, or they can hold it and use it as working capital. I mean, it will get put to use. There's cash management techniques that will get put to use. The question is, what's the highest use? And bond repayment, I don't know the terms. I frankly am ignorant of the terms of their existing debt. So if there's a high prepayment penalty, they should not do that. But there's no requirement that they do that in a securitization transaction.
Thank you.
Thank you very much.
Okay. Well, Mr. Benz, Commissioner Benz, we're glad to have you here. Thank you for your testimony.
Thank you all.
Wait a minute. Any redirect, Ms. Jones?
No redirect.
Sorry about that.
No redirect, Mr. Chairman.
Okay. We're going to excuse you, and I appreciate you when you're talking old, looking at Commissioner Howard. So that was.
He's hiding behind his nameplate there.
I understand that.
Thank you all.
Thank you. Okay. Next witness.
Your Honor, we would call Dr. Uday Varadarajan.
Mr. Chairman, I am going to want to use the Elmo just for one.
Okay, we'll get Mr. Erskine up here.
Thank you.
Thank you, ma'am.
Go ahead and get started while Mr. Erskine's setting that up. Thank you, Mr. Chairman.
Sure. I do.
Please state your full name and business address for the record.
Uday Varadarajan, and I'm a principal at Rocky Mountain Institute, 2490 Junction Place, Suite 300, 200 Boulder, Colorado, 80301.
And could you please summarize your education and professional qualifications for the commission?
I am a PhD in physics. I have most recently been a principal at Rocky Mountain Institute and for the last few months, and prior to that at CPI Energy Finance, primarily focusing on energy and finance issues having to do with clean energy and the transition from fossil energy sources. Prior to that, I was a program examiner in the White House Office of Management and Budget, and I had oversight over the cost to government of loan guarantees and loans made through the auto manufacturing program. And prior to that, I worked as a fellow as a Science and Technology Policy Fellow in the Appropriations Committee in the House, and as a fellow in the Department of Energy.
Dr. Varadarajan, did you cause to be pre-filed 22 pages of direct testimony in these dockets on September 24th?
I did.
And did you also cause to be pre-filed 8 pages of surrebuttal testimony in these dockets on October 29th?
I did.
Are there any corrections or changes that need to be made to either your pre-filed direct or surrebuttal?
Yes.
Can you please talk us through that?
I'm asking to make a change on page 8 of my surrebuttal testimony, lines 8 through 10, and the correction is it should read, on balance, if it becomes a viable legal option, there is no good reason for the Commission not to provide additional ratepayer relief using a tool that many other commissions in many other states have used.
Thank you. And other than that correction, if the questions put to you in your testimony were asked at the hearing today, would your answers be the same?
Yes, they would.
And Dr. Varadarajan, did you prepare one exhibit attached to your pre-filed direct testimony, which was pre-marked as UV-1?
Yes.
Did you also prepare one exhibit attached to your surrebuttal, also marked for identification as UV-1?
Yes.
Are there any corrections or changes to be made to those exhibits?
No.
Mr. Chairman, I would move to have the direct and surrebuttal testimony of Dr. Varadarajan entered into the record as if given orally from the stand.
Okay, the pre-filed direct testimony and surrebuttal testimony of Dr. Varadarajan will be entered into the record as though given orally from the stand.
And I would also move to have the exhibits attached to his direct and surrebuttal testimony entered into the record as the next hearing exhibit.
Okay, Dr. Varadarajan's direct exhibits, I think that's UV1, will be entered as exhibit number 95, and surrebuttal exhibits will be entered as exhibit 96.
Thank you, Mr. Chairman. Dr. Varadarajan, did you prepare a summary of your direct and surrebuttal testimony?
I did.
Would you please deliver your summary to the Commission?
Thank you. First of all, thanks so much again for the opportunity to discuss this topic before the Commission. My name is Dr. Uday Varadarajan. I'm a principal at Rocky Mountain Institute, where I analyze clean energy policies and utility finance and business structures. My testimony outlines the benefits of securitization for SCE&G ratepayers and addresses concerns about the potential impacts of securitization on SCE&G's credit rating. My testimony is based on an evaluation of 6 different VC Summer NND cost recovery scenarios. First, the 3 plans SCE&G included in its January 2018 application. Then a continuation of the 15% rate cut put in place by the South Carolina General Assembly this summer. The merger plan modified to use the $1,000 check upfront cash rebates to instead offset rate base. And finally, a plan where no additional VC summer costs are allowed into rates. For each scenario, I compared traditional utility financing with financing through a corporate bond or through securitization. My analysis uses assumptions provided by the joint applicants and is informed by the dozens of cases across the United States where utilities have successfully securitized the debt of stranded assets to lower customer costs. I conclude that securitization offers SCE&G customers significant benefits in all of the VC summer cost recovery scenarios I looked at. Securitization can save customers between $0.5 and $2 billion in net present value. To put that in terms of bill savings, that's a reduction of about 2 to 10% from current levels. Securitization of a no-merger plan provides greater savings than those Dominion has offered to customers through its merger customer benefits plan. And using securitization in the customer benefits plan could be even more advantageous for customers. Due to the timing of filings, I was unable to compare the customer benefits plan with the ORS optimal plan or alternative Dominion proposal, but I would expect securitization to also be beneficial in those two scenarios. There are minimal economic downsides for SCE&G associated with securitization. In fact, securitization could help the company recover financially. The company could use some or all of the proceeds from securitization to buy down more expensive debt and improve the company's credit. Without a merger, securitization has a minimal negative credit impact on SCE&G, regardless of whether SCE&G uses securitization proceeds to pay down debt alone or pay down both debt and equity. Securitization alone would not cause the company's credit rating to fall below investment grade. In merger scenarios, securitization has no long-term adverse impacts on the company's credit rating. Near-term impacts can be diminished by using securitization proceeds to pay down debt. And even if securitization is not used solely to pay down debt, negative credit consequences do not persist beyond 3 to 5 years. I've included a figure that illustrates the primary findings of my analysis with or without the merger. What I find is that securitization can bring down ratepayer costs while mitigating SCE&G credit impacts. And I've really highlighted 3 scenarios in that figure. First, I've looked at what I call the Act 258 scenario, which is continuation of the Act 258 rates. Second, I look at the customer benefits plan scenario. And third, I look at a variant of the customer benefits plan without the upfront rebate. The figure shows a range of financial strength scores for each scenario based on how the securitization proceeds are used, either to pay down debt alone or pay down both debt and equity on the horizontal axis. And on the vertical axis, whether the securitized debt the total present value of revenue requirements associated with each of those scenarios. And I should say that the other options that are considered with the securitization scenarios here are whether or not the debt is consolidated on the balance sheet of the utility in calculating the financial metrics on the horizontal axis. And what you see in that figure is that the aggregate financial strength factors all are above the threshold to be investment grade 5 years after the bond issuance in all of these scenarios. And that securitization lowers the present value of revenue requirements relative to traditional utility financing in each of those scenarios, regardless of how those securitization proceeds are used. So as you can see, the bottom line is that customers can save money with securitization in all 3 scenarios, and in none of those scenarios does SCE&G's long-term credit rating fall below investment grade. In my testimony, I also describe how securitization could further benefit SCE&G and its customers through the use of capital recycling. What I mean by that is that the company could reinvest some of the proceeds from securitization into inexpensive clean energy. Renewables are now cost competitive with older coal and gas-fired power plants, even on a marginal cost basis. And replacing older fossil-based energy generation with clean energy could decrease the fuel and operating costs passed on to ratepayers. At the same time, investing in clean energy could replenish the company's rate base and generate additional cash flows that can be used to make interest payments on its debt, thereby also improving the company's credit rating. Securitization has been used in more than a dozen states since the late 1990s to reliably lower the cost to ratepayers. And just 3 years ago, securitization was used to save ratepayers in Florida nearly $700 million in costs for a $1.3 billion securitization associated with the abandoned Crystal River nuclear plant. My analysis shows securitization could be even more beneficial for SCE&G's customers. Due to the significant ratepayer savings associated with securitization and the minimal credit impacts for SCE&G, it is in the best interest of SCE&G customers for this commission to impose a securitization-related condition in its order. Once the commission has made a determination about which costs associated with the abandoned nuclear project were prudently incurred, the commission should require SCE&G and Dominion to use securitization to recover those costs. The commission can make this requirement contingent on the General Assembly passing enabling legislation. This concludes my summary.
Thank you. Dr. Darajan is available for cross-examination.
Thank you. Mr. Gao.
Thank you, Mr. Chairman. No questions.
ORS. All right, tell me one more time how to say your name.
It's Varadarajan. Uday.
Varadarajan.
Exactly.
Okay. See, I do public address for Presbyterian College football, and I have lots of cool names I have to pronounce that you don't often hear in Clinton, South Carolina, so I like that. Thank you. I'll try to do it again right next time. You may have to say it again.
I may take a shorter route. Is it Dr. Uday?
Uday, yep.
Uday.
Chicken.
That's right. Thank you so much for your testimony today. A few questions, if you will. If the merger does not go through, do you believe bankruptcy is likely?
From my analysis of several of the scenarios, there are non-merger scenarios in which the credit rating impact is manageable. And so from that perspective, while it is contingent on the amount of recovery that that the company is permitted, there certainly are scenarios where without a merger, where the company would not likely even see its credit rating fall significantly below investment grade, let alone be at risk of bankruptcy.
Would it be fair to say that the more allowable new nuclear abandonment costs that the commission is permitting the company to receive, the less likely?
Yes.
Do you believe SCE&G's bond rating would fall below investment grade if the merger does not go through?
Again, it's contingent on the level of recovery and on whether or not securitization is used and how it is used.
I was going to ask you this next question. I think the answer is going to be the same. Do you believe SCE&G's credit rating will fall below an acceptable rating if the merger does not go through?
Again, that's contingent in the same way.
And this is going to securitization. If securitization occurs, do you believe that bankruptcy is likely?
From my analysis, I believe that securitization in general, in previous cases, and from what I can see in this case, is credit positive, and that in the past, securitization has been used in part to help address financial challenges like these. And so I don't believe that securitization is likely to increase the chance of bankruptcy.
And I was following along in your summary. You stated that securitization alone would not cause the company's credit rating to fall below investment grade. Is that correct?
In the three scenarios listed that I considered, that's correct in the long term. Mm-hmm.
And you found that securitization has no long-term adverse impacts when the company uses securitization.
That's correct.
I also believe you testified that due to the timing, you were not able to look at the ORS optimal plan or Dominion supplemental offering.
That's correct.
That takes out some questions. I believe this is obvious, but just to have it on the record, would it be fair to say that your testimony really goes to support the position that under any scenario adopted by this commission, the securitization provides the greatest savings to ratepayers?
Yes, it does. And just in response to your previous question, I should note that the two scenarios that we highlighted, other than the customer benefits plan, the Act number 258 scenario and the customer benefits plan without the upfront rebate, share some significant characteristics with the ORS plan and the alternative customer benefits plan, respectively. And while they aren't perfect substitutes, there are many characteristics of those plans that I was not able to model. They are representative of scenarios similar to the ones that I was not able to model. And so while I can't say directly with my analytics so far what the impacts would be in those cases, these are suggestive results.
All right, and it is your recommendation to this commission that the commission require some language in its order that would allow the use of securitization, but contingent upon future legislative act.
That's correct.
Okay. Do you have an opinion as to why neither SCANA nor Dominion have considered putting forth a proposal to this commission that would include securitization as a contingency?
I believe that, as Commissioner Binns in his testimony discussed, generally speaking, if a utility isn't often pushed by circumstances like a significant disallowance to do so, the use of securitization essentially removes a significant regulatory asset from rate base, and therefore would reduce potential future earnings to shareholders as a result. And so wouldn't necessarily be something that a company would advocate for unless they were pushed by circumstances to do so.
Thank you. That concludes my cross-examination.
Thank you.
Thank you, Ms. Edwards. Other parties? SE&G, Dominion.
I have just a few, Mr. Chairman.
And Mr. Reed?
Good morning, Mr. Chairman. Joe Reed on behalf of Dominion Energy. Good morning, Mr. Varadarajan. How'd I do?
Very good.
Touche, Mr. Chairman. Just a couple of questions following up on the inquiry from Ms. Edwards just a moment ago on securitization. Am I correct that you analyzed several scenarios involving securitization, some of which included the assumption that the merger between SCANA and Dominion would go forward? Is that fair?
That's correct.
Right, sir. And you've read the rebuttal testimony of Dominion's witnesses in this case, I take it?
I have.
Including the testimony of Mr. Chapman?
I have.
Right. And do you have an understanding that Mr. Chapman has testified in this case that securitization as an option is not compatible with the merger benefits plan that Dominion has proposed?
I have read that that's not currently part of the merger discussion.
All right, sir. And in fact, he said it's not compatible with the merger benefits plan, right, sir?
I have read that that's not part of the merger as it's currently envisioned.
Fair enough. And you mentioned just a moment ago that if securitization of some or all of this N&D debt occurs, that would remove that asset from rate base and preclude the opportunity to earn an equity return on it, correct?
It does remove that asset from rate base, but as we discuss in other parts of our testimony, there is liquidity that's made available to the company that, with the Commission's approval, could be reinvested. And so it doesn't necessarily preclude the regrowth of rate base in future.
Fair enough. But as we sit here today, sir, you do not know whether Dominion would agree to close the merger if there is a merger condition imposed by this commission with regard to securitization?
No, certainly not.
Well, we'll have Dominion's witnesses address that when they take the stand. Thank you very much. That's all I have.
Thank you. Okay. Just going to check any more cross from. Okay. We're going to take about 10 minutes then for a break.